I am both a bankruptcy attorney and a divorce attorney, and so I'm going to talk for a little while about how bankruptcy and divorce affect each other from both directions. Mostly from a bankruptcy standpoint, because these videos are for people looking into bankruptcy. If you have a prior divorce and you're looking to file a bankruptcy, then there's a couple things we need to look at in terms of whether your debts are truly going to go away or not. First of all, are the debts joint debts with your ex-spouse? If they are, we're going to need to look very carefully at your divorce decree to see which spouse was ordered to pay those debts. If in fact you were ordered to pay those debts and to hold your spouse harmless from payment of those debts, then if you file a bankruptcy under Chapter 7, your promise to the ex-spouse will not be discharged. The debts themselves, the credit cards or car loans or whatever, will be discharged. But the minute they go after the ex-spouse for the money, the ex-spouse is going to drag you back into divorce court, and they'll be allowed to, because your promise to them to hold them harmless from those debts was not discharged in the Chapter 7 bankruptcy. If in fact you were ordered to pay the debts and you file under Chapter 13, then your hold harmless promise is dischargeable in bankruptcy. So if you file under Chapter 13 and pay only, say, 10% of those debts back, and the creditors all go chasing after your ex-spouse, and your ex-spouse tries to take you back to court, they won't be able to, because you discharged the ex-spouse's obligation as well as the creditors. Now, there are certain kinds of divorce decree debts that never go away, not even under Chapter 13. That is child support and alimony. And anything that can be proven to be child support and alimony, even if it's not labeled that in the divorce decree. Most of the time that's pretty clear in a divorce decree. Child support is child support and alimony is alimony. Once in a while there's a divorce decree that isn't very clear, where it isn't particularly clear whether the payment of some debts was traded for not paying alimony. And so there may end up being a dispute there. In those kinds of cases, oftentimes we're going to look at filing under Chapter 13 to discourage the pursuit of collection of those debts by the ex-spouse. But even in a Chapter 13 case, if it is proven to be child support or alimony, it will not be dischargeable and will still have to be paid, at least in the course of your plan in Chapter 13. A couple of other issues regarding the intersection of bankruptcy and divorce. If you haven't filed for divorce yet, and you're thinking about it, and you're looking into filing a bankruptcy, you need to be aware that the divorce judge is going to have broad discretion in dividing up liabilities after you've filed your bankruptcy, if you do the divorce afterwards. And so there could be unintended consequences. For instance, you could discharge all of your debt. That would bring your budget into line and make it appear that out of what's left, you have an ability to pay some of that debt. And that might give your ex-spouse sort of a leg up in the divorce fight. So if at all possible, it's better to get the divorce out of the way first and then figure out where to go with it. If it can't go that way, if you're simply must file now, I've never seen a divorce judge impose the payment of liabilities on a debtor who has discharged those liabilities in a bankruptcy. And so you're still probably in good shape. It's just easier if we can get the divorce decree taken care of first. With respect to the filing of a bankruptcy jointly with a spouse, it can be done at any time as long as you are still married. The day your divorce is final, you can no longer file a bankruptcy jointly with your ex. So I do have many clients and have done many cases in the past for divorcing couples where they didn't want to have to argue about the debt, so they wanted to get a bankruptcy out of the way before they even got the divorce over with. So they would file the bankruptcy together, take care of all the debts, then divorce, and they could save money by filing only one bankruptcy case instead of two, and then not have to argue over the debts in the divorce case. In the course of teaching a class on bankruptcy and divorce at the American Bankruptcy Institute conference in Denver, I had a lot of questions from attorneys all over the country about, what order to file in, whether you should do the bankruptcy first, the divorce first, and many, many attorneys who didn't understand the interplay of Chapter 7 and 13 on hold harmless agreements and divorce decrees. And so, like any other area of the law, it's very important to find competent counsel with experience who knows what they're doing and will steer you in the right direction to get the right kind of bankruptcy filed at the right time.